Good morning, how I'm audible. Good morning, this beautiful morning.
Good morning, sir.
Okay, great. Yeah, so how we are doing fine.
Yes, sir. Yes, sir.
Yeah, to God be the glory. Yes, I just to before we start random presentations, I just want to say that despite the little warning, um, I'm a bit I'm really disappointed that some people are submitting their paper, their assignments after the deadline. So we all know the implications. So we are law students. I will set the rules for ourselves. I will have to abide by the rules. So and it's beyond me as an individual. So I have a superior that I report to. So if you have submitted your assignments beyond the deadline, please, there's what I can do about it. So, and just to reiterate my earlier instructions, you look at the screen, you are going to see it being displayed all over again. So that I don't want someone to come and meet me in the office like February I've been doing. Please don't come and meet me in the office and make some excuses that are not tenable. Okay, so the assignments that we give was to be able to assist all of you. And if you have not shot yourself in the leg by submitting beyond the deadline, then you have yourself to blame. I'm sure, Oladele, can you see my screen? You don't have been
Yes, sir.
okay.
Yes, sir.
Just to illustrate again that the answer should not be less than two pages and more than 2.5 pages, word type excluding the title page. That is for the for question 1. Then for question 2, the answer should not be less than 2 pages and not more than 3 pages, word typed excluding the title page as well. So, and where I'm even going is the instruction parts. Yeah, so the formats: answer each question in a separate paper and indicate each question on the paper accordingly. You have to submit the hard copy of your work at the Department of Private and Property Law. The pages must comprise of font size 12 times New Romans 1.5 spacing. Then the submitted paper will be subject to AI and plagiarism check, and any papers that fall short of this required standard will be severely penalized. Students should ensure that their material number have been accurately typed before submission. To submit the soft copy of your paper, send the 2 assignments as one file to ISSA ADEDOKUN@gmail.com. Follow the logical structure, introduction, main points, conclusion. And now deadline for submission, hard copy submission, 10th February 2025. That's on or before 10th February 2025 at 2 p.m. So 2 p.m. is deadline. So if you cannot submit your paper before 2 p.m. today, please do not reach out to me. Do not reach out to me. We are being recorded live. I'm saying this again. Do not reach out to me. Okay, so you can direct your complaint to the head of department if you have any complaint, whether medical or not that, but please do not come to me. Okay, so then online submission, Sunday 9th February 2025, before 3 p.m. So this morning I'm seeing, I opened my mail before I came to class this morning, and I'm seeing 10 p.m. 10 p.m. on the 9th. I'm seeing even this morning, people are submitting this morning. So I saw 7 a.m. I saw 5:30 a.m., 6 a.m., and so on and so forth. Please, I'm begging you again, do not come to my office to solicit for assistance on this matter. People submitted after the deadline will not be counted. That is the instruction that we give. So now, Okoli, you were raising your hand, and FIFO, how about as well?
Yes, good morning, sir. Please, I wanted to mention the hard copy submission, the deadline is by 2 p.m., but most of us have classes from 9:30 to
I
3:30
can't
p.m.
I
back
can't
to
hear
back to
you.
back.
I can't hear you.
Okay, sir, can you hear me now?
Okay.
Sorry.
Go ahead.
Sir, I was trying to mention that the hard copy submission deadline by 2 p.m. Most of us have classes from 9:30 a.m. to 3:30 p.m. back to back on Monday mornings.
Okay. So the allowance of 130 minutes that you have, what's the purpose for that? I'm asking,
I
did
didn't
I tell
get
you
that.
the allowance of 130 minutes that you have, if you have class back to back, the allowance of 130 minutes that you have before 2 p.m., what is this for? What do you think that 130 minutes for? Then did I tell you that ordinarily you ought to have submitted your paper before if 2 p.m. on Friday, but I'm giving allowance for those that that don't be around. And some of you ask questions that can we submit by proxy? And I say yes. So that's not an excuse, please. At all. That's an excuse. But we're giving it to be an open book test. Who to submit that minutes. So again, who again before we go on so that we know lose our time. Moses.
Okay, good morning, sir.
Yeah, good morning.
Okay, sir, you indicated I just wanted some clarifications. You indicated in the instructions that the assignments should be submitted in separate papers. Does that mean when we're submitting physical, we are submitting two separate documents for the two questions?
That when you are writing white exam, don't you follow instruction that they put on the white or on the instruction column? It's clear now. It's not clear. So I'm just being magnanimous by interpreting again. So it's not clear. I shouldn't be interpreting to you anyway. It's clear now.
Okay, sir.
So, and I could see some of my friends are already doing that. In fact, I met one at the staircase this morning. I said I want to come and submit. Bisola, Bisola, are you in the hall now? Bisola, are you in the hall? Bisola, can you hear me? Bisola, I met Bisola at the staircase this morning, and she told me that she was coming to the department to submit. So why is it not? Why is it an issue? So the instruction says that you have to submit. You have to submit differently. So, but that you can for the online submission, you put them in one single document because it means that you could access everything. But for the hard copy submission, you submit differently. Is that not clear? So
Okay, sir. Thank you, sir.
now, Oluede, please, I just want to know some time on this thing. I don't want the class to be saying all this I'm repeating, but just to dissuade you from coming to my office because I will not welcome that. And if you go to my office, that can come for another mark subtraction. Please. Look, I have so much to do in my office to be receiving student complaints. If you have any complaint, I'll take it to the departmental office and they will treat it. Okay, quickly, fast.
Sorry, sir. Good morning, sir. Sir, I wanted to ask for the online submission of yesterday that some of us actually submitted before the deadline, but for some network reasons or something, we do not know when it exactly sent. It was in pending mails. So if it's within the range of something around from a little some minutes past 3, would this be accepted?
Now, is that lady or Favor? Is that lady or Favor that was talking?
Only this, sir.
Okay, and now if you did law of contracts, I remember the principle in Adams and Lissel. You remember the principle in that case? Do you remember the principle, your law of contract principle on acceptance by mail or by post?
Yes, sir. Yes, sir.
Okay. All right. So I say no more on that. So now Olani.
Good morning, sir.
Yeah, good morning.
Yes, sir. Sir, about the hard copy submission, you just mentioned that we should submit it separately. What about those of us that have submitted earlier today and have submitted it together?
But you read the instruction now.
Yes, sir, but in the instruction, it was not stated that hard copy submission should be separately.
Class, please, can you protect me from Olani? Was that the instruction?
Yes, you just said to submit the soft copy of your paper, send the two assignments, not PDF, as one file. There was nothing about hard copy submission.
Okay, see, let me read to you again. You know me, I be advised to go and become a judge, but I refuse to become one because of the conservative nature of the job. So see,
Yes, sir.
if I'm a good judge, of course, I have a listening ear, so I will listen to everyone, and that will not affect me in any way. See what I'm talking. See what I'm talking. It says, answer each question in a separate paper and indicate each question on the paper accordingly. You have to submit a hard copy of your work at the Department of Private and Property Law. So if you have an instruction like this, answer each question in a separate paper and indicate each question on the paper accordingly. So what is that supposed to mean? Well, if the instruction is
It
not,
means we should answer it separately.
if the instruction is not elastic enough, okay, for those that are submitted together, but name your question differently and start afresh,
Yes,
afresh, we'll give it to you. Is that all?
Okay, thank you very much, sir. Yes, sir.
All right. So let's start with this class now. I guess let me just make this point known so that we'll be on the same page, and so I not say that was a wicked man. I've been giving us the chance to do assignments as again the CA. He has now stop us from submitting. Now, so for today's presentation, before I go into calling names or I request for volunteers, I want to say that I mentioned last week when I give the requirements for the liability for independent contractor, which I repeatedly. Okay, so and please know those three requirements that I mentioned. Then for the liability to trespassers under the provision of Occupants Liability Act of 1984. Also note the following. I'm sure some of you have read it, and also for those that have been following me in class, you have also noted it down. So, and please let your class chair remind me, if time permits, because I want us to wrap up by today is 10. I want us to wrap up by this Wednesday. So I'm going to complete our discussion today. If you are able to maximize your time on the presentations that we are set to embark on, we're supposed to finish our lectures, past questions, tips on how to answer low questions this Wednesday. So, but let your class remind me. I learned, I think from the timetable, from the draft timetable that we have, your TOT exam should be 26th. Am I correct? Of July, of February. Can someone answer me? If you are familiar with your timetable,
Yes, sir. That's correct.
Yes, sir.
Of February. So what that simply means that we need to end our class officially by Wednesday this week, so that you have time to go and prepare. And if you want us to come back once more, I can volunteer to streamline all that I've discussed with you 1 weekend. You know, this is very well. It is not compulsory. If you permit me, that's what. If you permit me, I can volunteer to come to your class to streamline what I've taught you. One of these weekends. So, if you want that, you can get to me. You can get back to me through your class rep. Even if you don't want that, they will meet in the exam. So now, look at we have discussed about liability to trespassers, and we've all agreed here that unlike the 1957 Act, Occupiers Liability Act of 1957, that duty of care was not owed to trespassers, except the general common, except the fact that the occupier should not intentionally put the trespasser into risk, unnecessary risk or unnecessary danger. But by liability to trespassers under the Occupiers Liability Act of 1984, we also mentioned that act established the duty of care towards trespassers. Now, for that duty to exist, you must note three points. For that duty to exist, to trespassers, you must note these three conditions. One is that the occupier is aware of the danger or has reasonable grounds to believe that it exists. Again, that the occupier is aware of the danger or has reasonable grounds to believe that it exists. Two, the occupier knows or has reasonable grounds. The occupier knows or has reasonable grounds to believe that the other, that is the trespasser, is in the vicinity of the danger concerned. Is in the vicinity of the danger concerned, or that he may come into the vicinity of the danger. So that's number two. That is, he knows or has reasonable grounds to believe that the trespasser is in the vicinity of the danger concerned, or that he may come into the vicinity of the danger. So he must have reasonable grounds to believe that the trespasser is in the vicinity of the danger in question or concern, or that he may come into the vicinity of the danger. And lastly, that the risk is one which in all the circumstances of the case, the occupier may reasonably be expected to offer the other some protection from. The last one is that the risk is one in which all the circumstances of the case may reasonably be expected to offer the other some protection from. So note these three conditions before before an occupier will be said to have duty towards trespassers. So now, where a defendant actually knows of a risk, or actually knows that the trespassers are or may come within the vicinity of his occupation, then there's little problem. So what tends to arise in the cases are the issues of what will amount to reasonable grounds to believe that a risk exists and reasonable grounds to believe that a trespasser will or may be in the vicinity. So all this still points to the circumstance of every particular case. So on this proposition, you can look at the case of swine and the natural ram puri. Swine is spelled S-W-A-I-N, and natui ram puri, N-A-T-U-I-R-A-M-P-U-R-I. So if I'm done with my slide, I'm also going to forward all these cases to you so that you, when you are doing your personal reading, you follow through. You can also look at the case of Higgs and Foster. Higgs and Foster. Okay, and finally, look at the case of Scott and Associated British Sports. Scott and the Associated British Sports. So, these cases explain the three conditions that I have just highlighted. So I think on that, we are done with that, with the discussion on the compatibility. Now, don't forget that I also mentioned that you look at the defenses, various defenses on to occupant stability, and I highlighted some of them last week as well. Before I give an assignment on the distinction between warning, exclusion, and the disclaimer. So I'll be on ground 2 minutes now to take presentations on the assignment that I gave, which is on distinction between fundamental distinction between disclaimer, exclusion clauses, and also warning. So I'm coming back to that now. But again, I also want to advise that if you see a question in the exam on remedies, now I'm sure at the beginning of this class you have been taught remedies. If I'm not mistaken, Professor Chumba has taught you remedies when she was taking you through the introductory aspect of law of torts. Am I correct? Class, answer me now. Am I correct?
She did not, sir.
Wait, oh, she didn't? Are you sure you didn't do anything like remedies at all? Maybe like remedies to tortious liability? Generally. Mr. Sister, can you answer me? Because it's like the class is being quiet. Mr. Ike Great Osita. Mr. Osita. David.
No, sir.
Sir, we usually did it, but it was usually part of topics. Like we didn't treat it exclusively.
Exactly. So most likely we are going to treat remedies also in second semester. But I would just advise that in case if a question will come out under it, if I'm asked to set question under it, you need to read remedies in tort generally. Okay, and so of course, like we have looked at the rules on whether a defendant can be liable in tort from the sort of trespass to land that I taught you to occupant's liability. We have seen that where the claimant is able to prove his claim before the court, then he's entitled to certain remedies. So some of these remedies are damages. Of course, I personally took you through damages when I was standing for Professor Chumba at the beginning of this of the torts or the torts class. So look at damages. Okay, so in the vast majority of cases where damages are claimed, they are what is known as compensatory types of remedies in law. And we said damages means compensation. So then the principle behind compensatory damages is that they should put the claimant in the position they will have been if the tort had never been committed. So note that principle very well. So, and again, we have some types that are also non-compensatory in nature. Okay, so but no damages or I don't want to waste our time on this very simple terrain. So read remedies in torts generally. So and also I would advise that you have to know the difference between pecuniary and non-pecuniary damages. Pecuniary and non-pecuniary damages. Okay, so now what is the rationale behind awarding damages in court? Now, the principle of restoring the claimant to the position they will have held if the tort had not been committed is called restitutio in integrum. Okay, I'm sure some of you have read that even in your legal method. Yeah. Other day, what are you saying? Adedeji. Other day, Adedeji, machine number 230601531 under the tree. What were you saying? Adedeji, what are you saying now? Can you hear me? Olalude Ayodeji.
I'm sorry.
Okay, so you were. I thought you were contributing to my discussion. You know, to be sure, sorry now. I thought you were contributing to my discussion, so I want to hear you loud and clear. Okay, so now you also need to know how to calculate compensatory damages. And like I said, the principle of returning the claimant to the position they would have been if the tort had not been committed is called restitutio in integrum. That is restitutio in integrum. So there are actually two different sort of losses as well. Pecuniary, which means financial, and non pecuniary, which means losses other than those of money. So you look at the examples of losses. So examples of pecuniary losses will be loss of earnings as a result of an injury, or a house being worth less than you paid for because your surveyor, for example, negligently failed to spot the defect in it. Look at the case of Farley and the Skinner. So I'm sure just go through remedies if you can. I just for purpose of knowledge, go and read through them, and if time permits, I can still I'll send note as well of that will guide your understanding. So then, aside from that, you can look at aggravated damages, pecuniary damages, aggravated damages, then what we call nominal damages, contemptuous damages. So now, when we talk of nominal damages, an award of nominal damages is normally made where there has technically been an infringement of a person's legal rights, but no actual damage has been done. So where you cannot prove special damages, as special damage in court, but you're able to show that there has been an infringement of your legal rights, but no actual damage has been done, then you can get nominal damages. So nominal damages is more sum of reward from the courts, but it's still damages that shows that there's been an infringement of a person's legal rights. Okay. Now, when we talk of aggravated damages, aggravated damages is where a defendant has behaved in such a way that the claimant has suffered more than would normally be expected in such a case. The court can show its disapproval by awarding damages which are higher than would normally be appropriate. So these are called aggravated damages. So I'm going to also send some cases in this regard. Then you have what is called exceptionally damage, the case as the name implies. So these are damages that involve paying the claimant more than would normally be appropriate, but they differ from aggravated damages in that the purpose is actually to offer a serious punishment to the defendants and to deter others from behaving in the same way. So it's punitive in nature, just like in criminal law. You know, the aim of criminal law is to punish. But there are instances whereby the court may award damages that are punitive in nature. So that's what we call exceptional damages. So please, I'll read through this so I will not waste our time on remedies generally. So now, having said that, I'll now welcome. This is 10 o'clock. So for the next 1 hour, I would now like to welcome some presentations on what we have done previously. That is the assignment that I gave you on warnings, disclaimer, and exclusion clauses. Please, master these three concepts very well, it may just be like an adjunct to a question under compatibility in the exam. So for some of you that want to answer a question on compatibility, you may need to be able to differentiate between warnings, exclusion clause, and also disclaimer as arms of defenses to occupiers' liability. So, sorry, may enjoy. How about this well?
Yes, sir. Good morning, sir.
Good morning, ma'am.
Sir, please, I want to ask you a question.
Okay.
So, sir, when you were teaching us, I think 2 classes ago, you made mention of people that have the right to enter in their like situation where there are implied consent in the cases of police officers and other law visitors that like the law permits to come into your premise. So, sir, I want to ask a question in that regard: that what happens in a situation where say a NEPA official that has been permitted to enter your your premises by law? What happens in a situation where he becomes a trespasser ab initio? That's the only way I can put it. Like, he goes outside the scope of his duty and like starts misbehaving. At that point, what duty of care do you owe to him? Will it still remain the duty of care under the 1957 Act, or it will shift to the common duty of humanity under the 1984 Act, such that if anything happens to him and you are able to fulfill these 3 conditions, you will not be liable? I just want to confirm that, sir.
Yes. You recall that I mentioned that these are the visitors that are permitted by law. I do recall that I mentioned that point, that
yes.
Those that have statutory duties to enter as of right to your premises, that you owe them duty of care to ensure that you don't put them into danger. So now this, but a clear point that you made now is what becomes the extent of duty of care owed by the occupier in the case where they have now gone beyond the scope of the authority. Did I summarize your question very well?
Yes, sir. Yes, sir. That's right, sir.
Okay. So in that situation, you know, the purpose of I mentioned earlier that lawful trespassers can become lawful visitors can become trespassers. So in that situation, when they are part of the scope of the authority, then they can become trespassers. So at that point, what you now owe them is the duty of a common humanity to ensure that you don't endanger their life beyond reasonableness. So that answers the question.
Okay, thank you, sir.
Okay, who is David Akinola?
Yes. Good morning, sir.
Yes,
so what I wanted to ask is actually similar to Joy's question.
Now, please, before you go, David, you know, don't forget that I under trespass to land, that trespass to land and occupability, they are not the same, but they share some similarities in the way and manner a lawful visitor can turn to a trespasser. And I'm happy or Joe was able to bring that question out. So that, and again, notice that it's not possible, that's for me, it's not possible for me to give a question exam, and for me to lump trespass to land with occupier stability. If I want to give you a question exam, I can only give you a question that borders on a particular topic. I cannot give you a polling question. I will now merge trespass to person with occupier stability with trespass to land.
300.
That would be total wickedness. Do you get the point I'm making now?
Yes, sir.
So that don't be over syllabus. When you see a question, read clearly, read the question very well. And that's not only me. That's not only me. I've not seen a lecturer that will set question that will not lump all the issues from trespass of land to a defamation to this and put them in one question. No. So read clearly the instruction very well. Read within the line. They may look alike when you are reading your facts, your scenario, your situations. But definitely, where the market scheme is going, we will teach towards a particular direction. And that's the direction that you need to master. So for them to have spotted that distinctions, it shows that she's reading and she's paying close attention to what we're doing in class. Okay, so David.
Okay, sir, that's all, sir. I think I've gotten a bit of clarity.
Okay, all right. So now, before I go on, who is match number 21601139? Is it in class or is it on YouTube? Match number 210601139. Class rep. Class rep. Wow. A class rep, you're not here again. Deputy class rep. Deputy class rep.
Good morning, sir. Good morning, sir.
Yes, good morning. Where's your class rep? Last week you mentioned that it was in YouTube. On YouTube. Now the class is just 251. I'm seeing because you are done with your test, people are not coming to class anymore. This is 251. For the past 10 minutes, the number has been oscillating between 240 to 250. So this is 251. So where's your class rep? Deputy class rep, where's your class rep? Ayomide, I can't hear you.
Sir, he's been complaining that his network is bad, so he's been logging him out of the class.
He's been what?
His network has been logging him out of the class, sir.
What would the network log your class rep out?
Okay. They don't have network where he stays. Sorry, sir.
Okay, wait, because I've warned you several times. This is a digital learning. So if I could put all my resources to ensure that I have data to be in your class, I don't see reason why somebody will complain about data or about a network. You should try and move to a place where you can have a strong bandwidth. It's not fair on the he's a class rep. He's supposed to be here. I've been calling his name since. He's not answering me. And you as a deputy class rep also, you didn't say anything or they call your name. If class rep is not in class, then you step into the issue. Okay, so mention about because he sent a message about some of your classmates not able to submit the assignments within time that they submitted a few minutes after because of network. So I'm calling him to find out the lady who came to my office, and I'll be calling the matron about the lady. She is not answering. So if the lady is not here, then there's no way I can pass my verdict about whether to assist her or not. So if matron about 210601139 is not here, then I can't help her anymore. So I asked her to be in class so that she can make presentation. Then from there, I will not say I can accommodate not able to submit after the deadline. So it's off. Please tell match number 21 deputy class rep. Tell match number 210601139 not to bother me anymore. She's not here, so it's not bother me about our late submission. Do you hear me now? Ayomide, do you hear me?
Yes, sir.
Okay, please, let me pass my message to match number 21060-1139. She came into a class rep and she came to my office to say that she submitted to wrong email and she forwarded a proof to me. And I said, okay, when I come to class today, I will address it. So she's not here. So she shouldn't bother me again. Then for match number, because there are two of them. Match number 21060-1071. Choma, are you here?
Good morning, sir. I'm here.
Yes. Okay. So my verdict is that you submitted your assignment at 9:27 p.m.
On my end, it's 9:23 p.m. But I think either works.
Okay. Whether 9:23 or 9:27, it's still within the same range. So now that you're in class, I'm going to pardon you. I want to pardon you and the other lady, but lady is not in class, so I can't pardon someone that is not in class. So now, are you ready to make your...
Sorry, sir. Good morning, sir. I'm sorry for interrupting.
Are you ready to make your presentation, Chioma?
Yes, sir.
On the warnings and the... Sanusi Aliu, what is the issue?
Good morning, sir.
So I want to talk about the China's. It's China's though. They are having light issue in her class, and she mostly doesn't make it to class most times. So I believe that might be the issue.
Sanusi, I want you to become an
advocate. Good morning, sir.
Oh. So I called her phone now to switch off.
Good morning, sir.
I said, when do you become an advocate?
Good morning, sir.
Yes, who is that?
Good morning, sir. So yeah, she just reached out to me. She's watching on YouTube, sir. She's watching in class on YouTube, sir. She's in class.
Why would she be watching on YouTube when the capacity of class is 300? I'm still 255. So
she probably wasn't aware before. Probably wasn't aware before, but she's watching it on YouTube. She just texted me.
If there's no way you will not know. You can be on YouTube and also be on the same on the platform. The platform has capacity for 300. I'm still 255. So for YouTube, let me confirm those YouTube, but tell her to log in into the main auditorium.
Okay, thank you, sir. Thank you very much. Told her now. She's going to join. Thank you, sir.
Okay, if it's ready to present, fine. If it's not, then I can't pardon her.
Thank you very much, sir.
I have to be just. Okay, so for Chioma, can we have you now for just for 4 minutes?
Okay, sir.
Yes, then our president, they turn your camera on, so I'll let the classmate see you very well.
Okay. I don't know if she says.
Yes. Go ahead. On mute now, on mute.
I don't know if okay. All right. So good morning, everybody. When I was doing my research on the assignment I was doing, the differentiation, basically distinguishing between notice, exclusion notice, and disclaimer notice. Since I have 1 minute, I'm not really going to go into all the basically everything that I read my assignment. But one of the things that I noticed about the three of them was that the warning notice, focused mainly on bringing out dangers or risks that are existing on a premise.
Hey, class, can you hear? Can you hear? That is noisy somehow. Where she is noisy. Can you hear?
Can everybody hear me? I don't know. I'm using my phone, so I don't know if I should switch to the laptop. Can everybody hear me?
Wait, I doubt they can hear you. I doubt. Because
I can hear you. I can hear you, but it's just I think the network is breaking a little bit. I can hear her clearly, but the network is breaking a little bit.
Let me try using. Let me try using.
No, you're audible now.
Is it better now?
Yes, you are more audible now. You are more audible. You are audible. Go ahead.
Is it better now?
It's better.
Okay. So basically what I was saying was that the warning notice focuses more on bringing out, okay, this place is a place that is dangerous, this is where there is a danger. The disclaimer notice seeks to just absolve it, like whoever is the occupier of any form of liability, while the exclusion notice just seeks to reduce the liability. So I found let me get it. Okay, so for the exclusion notice in the case of Ashdown versus Samuel Williams and Son, the claimant was basically injured by railway tracks while they came on the premises of the occupier, right? And it was held that the exclusion notice could not absolve the occupier of liability because the person, basically the plaintiff, was not aware. No, actually, they were aware about the exclusion notice. I'm remembering another case. They were aware the exclusion notice was there, and they were aware, and so they said the claimant could not basically bring an action against the defendant because there was an exclusion notice absolving the defendant of responsibility. So this one was very obvious on the land. And then in the disclaimer notice, another thing that I observed is that it's usually for voluntary activities. So somebody can actually, it's almost like agreeing to a disclaimer notice basically is for people that, let's say you want to, for example, people that want to do like skydiving. So there's most likely going to be a disclaimer notice there for an activity. So it's almost like you're agreeing to the risk and they're saying that, if anything happens to you, sorry for my if anything happens to you as you're doing this thing, you will not be responsible for any injury that occurs like while this process is going on. And then for the warning notice, like I stated earlier, it's really about just bringing forth, although they aim to just reduce their liability, but it point mostly to avoid whoever is going to be on that premises of getting injured. In the case of in case of Rose and Nathan, two chimney sweeps were killed by carbon monoxide, but in this scenario, they were repeatedly warned by the occupier not to stay too long in that place. So he warned them of the dangers of excessive exposure to carbon monoxide, but they still stayed too long and they died. And it was held that the occupier was not liable. So they all sort of seem similar because they all are notices and they're trying to reduce or at least absolve completely the occupier of any liability. But then they have some tiny differences in the sense in their function. So, like I said earlier, which I'm just going to reiterate, a warning notice just brings forth danger, like, oh, this place is dangerous, this is this, that is that about the risk that can occur in this place. A disclaimer notice tells you of the danger also, but it seeks to absolve the occupier of any liability whatsoever, while the exclusion notice just seeks to reduce, or even if it acknowledges that there is some level of duty of care, but it wants to reduce that duty of care. Like, oh, I have a duty of care to protect you and keep you safe, but I'm reducing it. So if anything happens to you on this, you think I will not be responsible for some part of it, right? So it's not everything. I think that's the major difference between the disclaimer and the exclusion notice, is that the exclusion is just some part, just excluding some liability, but not it fully. So that's what I learned from my research and doing the assignment. Thank you.
Okay, so for Sanusi, what is it again? Sanusi, is it the same answer that's up, or you just or is a new intervention you want to make? Sanusi? Okay, so deputy class rep, is he in class now? Is your friend in class now? Oh, okay. So don't waste our time. Okay, so for I'll just leave it at that for now and see what others have to say. Because I was expect that going to also discuss the case of Rose and Nathan. When you were giving your highlight on warning. So, but let's see if another person is going to touch on that. So, Choma, I think that's all right. For Daniela, do I have Daniela? Daniela 210601026. Are you in class? 210601026. Who is Daniela? Jason. If I call your name and I am not answering, I'm going to give you some form of maybe -2. Deputy Class Rep, confirm if match number 210601026 is on YouTube.
Hello, sir.
So why are you not answering me?
So sorry, sir. Good morning, sir.
You have the floor now.
Okay, sir. Sorry, sir. My background is kind of noisy.
Turn on your camera. Turn on your camera. So I'm just speaking randomly. So for now.
Okay, sir, let me find a good background, sir.
So Obidile, after Daniela, you have the floor. Daniela, don't waste our time now. Time is going, please.
Okay, sir. Can you see me, sir?
Okay. So,
Okay, sir. So,
Daniela, when you turn to our mother of Jesus?
I feel early in the morning. That's right.
Okay, all right. So go ahead.
Okay, sir. So, the discussion of occupiers liability, where the discuss on disclaimer notice, exclusion notice, and warning notice, like what's it called? The notices that an occupier is expected to put up, maybe to what's it called, in establishing that he has either done his own part of duty of care to visitors that may get his property, maybe like visitors, trespassers, or people that by the permission of the occupier have the authority to enter into his premises. So, like in the assignment I submitted, the disclaimer notice can be regarded as notices that expressly indicate that the occupier does not accept any responsibility to look out for the safety of people in his land. So, what's it called? It's just like when you enter into maybe an advert or something, maybe a contract disclaimer. Those type of disclaimers are like just to put out the occupier, excluding himself from any maybe if there's an event of injury or accident, like try to put up a disclaimer that he will not be responsible. However, an occupier cannot just rely on just putting up this notice because there are certain limitations to this one. Like there are certain limits to the extent to which he can rely on it. So, like the assignment that submitted, I noted that the relevance of this notice comes to light when the occupier seeks to protect himself from certain liabilities, which may have ordinarily incurred from the unprecedented actions of persons that have in use of his land without his knowledge. So, I think what's it called? Like businesses now cannot just say that they want to put up disclaimer notices because it would be okay. The law already places a duty of care on them for them to like they are responsible for the safety of people on their premises. So they cannot just say that, oh, they want to put up a disclaimer notice to exclude themselves from any such responsibility because they have a duty of care that the law expects them to meet. Then on exclusion notice, like it reminds me of the exclusion clause we taught in law of contract. Exclusion notices are like express terms. They could actually be expressed or implied, but they're like terms that exclude the what's it called, a party in the contract from any sort of liability. So maybe in the event of an injury, like it is like you are foreseen in the event of any kind of injury or the other party are excluding yourself from any such liability. So there's like a relationship, but however, in the context of occupier's ability, the occupiers that you will be sued, but not to a large extent of loss or damage experienced by such a person while on its land. If such a person is a visitor, domestic occupiers can actually rely on this. But like disclaimer notices, business and organizations cannot rely on this as they owe a sense of liability to visitors or trespassers. So just like business, maybe like what you call people that run amusement parks, like Como Resorts now. Como Resorts like an amusement, like it's like a park. I think it's on the island, yes. So they cannot now say that for their recreational business. So they cannot say that people can come in to have fun, play on their swings, go on rides and all, and not say that, oh, if maybe something happens, maybe somebody falls down on this from the swing, and then it is noted that because of the swing is defective or it has not been like they've not established their own duty of care, they've not done their own part in making sure that people that make use of this. Thank you very much.
Yeah, thank you. You know, that aspect of you able to distinguish between for occupation for business purpose, okay, from the normal occupation is what I find very interesting in your work. So what is lacking in that analysis, maybe another person will help us to unravel that. So I think that's very apt. That's what I'm looking out for, and I'm glad that you're able to distinguish between when occupier is in charge of resource center, okay, and also when he just for ordinary use. So there's a particular law that made it compulsory or made it compulsory for the occupier to ensure the safety of those that come to educational center. When you have occupation for business purpose, you cannot exclude your duty of care. You cannot exclude your duty of care, unlike the ordinary course of activities. So let's move to those that indicated interest last week to make presentations. I have a Chooks. Chooks, are you here? I also have Olatunji. Then I have Aliyah. I have Good Success, Valentine, I think a Grace as well. So very good to these people. Let me if I call Grace, let me go to Obidili.
Okay. Good morning, sir.
So Obidili, why do you go to YouTube when the class is still, when the auditorium is still very much spacious? The space is still in the auditorium, and you went to YouTube. So that I will not call you to make your presentation.
No, sir. Sorry, that was not the reason why. So my Zoom on my phone was hanging, so I'm currently using my laptop. So I just got the laptop, and I've not been able to like finish setting everything. So
and your advocate told me that there was no light in your place. Maybe that was why your brother Sanusi Aliwaba said that because you don't have light, maybe you stay in the same place. I don't know. Say you don't have light, so that's why you could not make it to the class before your deputy class chair was able to find you out. Okay, go ahead. Let's see your camera. Go ahead and give us 3 minutes insight on what you find out in your assignments. In your assignment on those trial of warnings, disclaimer, and exclusion.
Okay, sir. So first of all, good morning. So the first thing is that legal notices are like very important because they basically help to limit legal exposure and to like manage liability, right? And to also inform individuals of risks. So I think the first thing to note is like what occupiers liability is all about. So occupiers liability basically confers liability on an occupier of land or premises for the injury, loss, or damage to property suffered by claimants while on the occupier's premises, right? So it basically imposes like a duty of care on individuals who occupy a property, right? Like, so the um the
Can, can
idea of
you can you cool your can you allow tension to cool?
Yeah.
You are talking to your classmate, so feel free to talk.
So the idea of occupier's liability is very broad because like when you look at the Act of 1957 and 1984, they basically like cover like trespassers. They include like they include this liability on both trespassers and visitors, even though trespassers like it only concerns personal injury done to them. So because of like how broad this is, like the act also allows it also allows these occupiers to kind of limit their liability in terms of in terms of damages done to the trespassers and the the visitors, right? So there are three major like ways that these occupiers can kind of like limit their liability, and they include disclaimer notice, warning notices, and exclusion clauses, right? So first of all, disclaimer notices are they basically like the primary deny responsibility. That's like the major aim of a disclaimer notice. Like when you pass through a compound now, you see disclaimer, beware of dogs. You know that once you enter that compound and like a dog bites you, the function of the disclaimer notice on that displayed before you enter the compound is to like deny responsibility. That, okay, I've actually warned you that there is dog. So if a dog bites you, like it is basically your own this thing. I'm not going to be held responsible. So basically, disclaimer notices are displayed to protect the owner or occupier of land or property from potential legal liability in the event of an accident occurring on the premises. So if there is like maybe if there's problem with like say like a sorry, if there's like problem in terms of like say the electrical wiring, and before a trespasser or a visitor enters the compound, there's a very clear disclaimer notice written that okay, there is electrical fault, so like beware, that kind of thing. So once they enter, like the aim of that disclaimer notice is to basically like limit liability occupier of that land that placed disclaimer notice. And this is very important in this thing in occupier's liability because it's kind of how am I going to speak? It kind of limits the duty of care that the owner or the occupier like basically has towards the trespasser or the visitor. Shit, I want to say something. So when you now talk about sorry, let me just run through this thing. When you now talk about like exclusion clauses refers to the act of explicitly stating what is not covered or included in a particular agreement or policy. So an exclusion notice basically seeks to restrict or eliminate this liability. They basically restrict this liability for anything. I know that you can also look at exclusion clause in terms of the fact that like it basically excludes certain people from accessing or using a particular service. Maybe you go to like a club now and it'd be like, okay, only members are allowed in that club. That's an exclusion clause to like every other person that is not a member of the club. So that's basically so exclusion notices can also be referred to as exemption clauses, and it can be defined as a contractual provision that a party would not be liable for damages he ordinarily would have been liable for. So according to Section 2, subsection 1 of the 1957 Act, it specifically refers to the right of the occupier to exclude liability or otherwise. So this is the provision in the Occupier's Liability Act that enables the occupier to like kind of exclude himself from certain liabilities, like in terms of like his property. So you can refer to the case of Ashdown and Samuel Williams. So because of how unfair the exclusion clauses can be couched at times in some jurisdiction, an exclusion notice must be fair and reasonable to be enforceable, and that like they are subject to various restrictions. So when you the fact that you exclude yourself from this liability, or you put up certain exclusion clauses, it does not necessarily absorb you completely. There are some instances where like the court would have to like apply reason and caution and be like, okay, this stuff is actually quite unreasonable to like the potential.
Thank you. Thank you. You have tried. Thank you. So you are forgiving.
Thank you, sir.
Oh, okay, so Grace. Grace.
Yes, sir, I'm here. Good morning, sir.
Okay, yeah, good morning. Okay, you have the floor now.
All right. Thank you so much, sir.
All right.
So, I like to start with saying that in normal parlance,
Let's have your camera now. Let's have your camera
I
on.
have to turn on my camera. Okay,
Yes.
sir.
Let them see you that you are the one talking, so that they won't think
Okay.
the ghost.
Am I audible and
Yes,
visible?
yes, very well, very well.
Okay, no problem. So when it comes to the use of disclaimers, exclusions, and warning in tort law, it's used to kind of mitigate or absolve the liability of an occupier. In normal parlance, they are used interchangeably, but you can actually differentiate these three if you can read the intent of the occupier. And the particular provisions that actually give effect to the use of disclaimers, warnings, and exclusions can be traced to section 2 subsection 2 of the Occupiers Liability Act of 1957, which states that section 2 subsection 1 of the Occupiers Liability Act of 1957, which says that
Class, can you see Grace? I can't see her again, no. But you can see her, no problem. Just go ahead.
you can. Oh, okay. So section 2 subsection 1 of the 1957 Occupiers Liability Act actually allows an occupier to limit his, like, if he is free to extend, restrict, modify, or exclude his duty by agreement or otherwise. That one has to do specifically with visitors. There's a similar provision in the 1984 Act, and also section 2 subsection 4 of the Act also allows for warnings. So to differentiate the three, we have to first of all look at the intent of each of these different notices. For a disclaimer, the occupier is saying we do not accept any responsibility for anything that is happening on this land. And an example was seen in the case of Ashdown versus Samuel Williams Limited. And in this case, the reason of this court was that an occupier that merely notifies a visitor that he was not accepting any responsibility for their safety, that particular notification would not be effective to disclaim the duty of care unless he must have invited the person to the land. The person that came, the visitor, must understand the notice. So unless those two requirements are not met, the occupier is not discharged of his duty of care under the Occupiers Liability Act. Now, this particular disclaimer, that is totally not accepting responsibility. It's not enough to absolve an occupier of liability in all cases. It might apply for business owners, but it can apply for domestic occupiers, but it cannot apply for business occupiers because Section 65 of the Consumer Rights Act and Section 2 sub 1 of the Unfair Contracts Term Act actually does not allow the occupier of a business premise to exclude liabilities or to use warnings or all these other notices to exclude their liability for injuries and deaths that occur on their premises. So the sum total of disclaimer is the occupier is saying we do not accept responsibility for everything that happens. But depending on whether the person is a business owner, this disclaimer might not be enough to absolve him from responsibility. So the next type of notice is a warning notice. So in warning notice, there's a particular danger on the land, and the occupier is bringing visitors and trespassers to the awareness of that particular danger. So when it comes to visitors, that is under section 2 subsection 4A of the Occupiers Liability Act of 1957. Lord Denning had already expounded this in the case of Rose versus Nathan, where he explained that a simple warning that tells somebody like, oh, if you want to, he gave an example that I think points it very clearly. He gave an example like, okay, if you want to access a house and there's a rotting bridge that's a dangerous bridge that leads to that house, if you just put a warning on that bridge and you say, oh, this bridge is dangerous, that warning is not going to exclude the occupier from liability because the visitor will still have to go through that bridge. However, if the occupier puts a warning on the bridge that, okay, don't pass this bridge, it is dangerous. Instead, there is another bridge nearby, pass this bridge. That warning itself will keep the visitor reasonably safe in all circumstances, and that is test for a warning. For a warning to exclude an occupier of his liability, that warning must be enough to keep the visitor reasonably safe in all circumstances. So in the second situation, when you give a warning of a danger and a particular alternative, then that would actually absolve the occupier of liability. Or another example, if there is a wild animal on a prey.
Grace, turn on the camera, Grace. Turn on the camera.
I should turn my camera.
Yes,
okay.
yes.
Okay.
Go ahead.
I actually left it. So okay. Am I visible now?
Yes, yes, yes.
Okay, no problem. So for example, if we say something like, oh, there are wild animals walking on this on a particular premise, right? And you just put a notice saying, oh, there are wild animals on this premise. That does not give the visitors or trespassers that will come onto the line, that does not keep them reasonably safe. So such a warning will not be sufficient to exclude an occupier from liability. Now, with regards to trespassers, the duty of care is lesser. So all that the occupier needs to do is actually to bring this danger to the trespassers notice. They don't actually have to go the extra mile that they will owe to a visitor to ensure that, okay, it makes them reasonably safe. So the long and short of a warning is that a warning is just telling a visitor or a trespasser that, look, there is a danger on this land, be careful. And in the case of liability, the occupier will most likely say, oh, I gave sufficient notice that there was a danger on this land. So that's what the occupier will try to rely upon. And similarly, it does not always absolve for liability. It has for visitors, it has to keep them reasonably safe. And for trespassers, sufficient notice has to be brought to the attention of the particular warning. Last one is an exclusion notice. So in an exclusion notice, what actually happens is the occupier is saying, well, I know there is a danger on my land, but before you entered into this land, you already agreed that you are not going to sue me for anything. So the occupier is aware that he actually does owe a duty of care to visitors and trespassers on his land, but he's saying he cannot be sued because before entry, the visitor or the trespasser agreed not to sue him. There's a particular case, I cannot remember it right now, but in this particular case, a man went onto a racetrack and he was injured in the racetrack. A car lost the tire hit him, and he died. So his wife sued the owner of the premises, and they said that, look, yes, we know that this place is dangerous, but that is why we put a lot of exclusion notices around the park saying that if any danger happens, we are not going to pay, you cannot sue us. And they agreed. That was the condition upon which they entered the premise. So in that particular case, the court held that the racetrack was absolved of any liability because they had specially posted notices that was excluding their liability. However, this particular case was decided before the Unfair Contract Terms Act of 1977 was promulgated. And the import of the Unfair Contract Terms Act and the Consumer Rights Act is that, like I stated earlier, occupiers cannot exclude their liability for deaths and injury that occur on their premise. So perhaps if that case was decided, or if it happened by the time that particular act was enforced, the park premises may not have been able to rely on that particular provision. So in conclusion, disclaimer notice, the occupier is saying they don't accept any responsibility, like they refuse to even accept the duty of care that they have under the Occupiers Liability Act and the other relevant provisions like Section 4 of the Lagos State Law Reform TORTS law. Then for warning, they're actually saying that there is a danger of this on this land, and we're bringing it to your awareness. And since we have brought it to your awareness, we would not be liable for any death or danger that occurs as a result of it. And third, for exclusion, they are saying we are aware of the danger, but you cannot sue us. Before you enter into our premise, you must agree that if anything happens to you on our premise, you will not be sued. So, sir, that was what I was able to get from my assignments. Thank you.
Yeah, thank you, Grace. That's a wonderful insight. But just to when you were making your presentation, you were talking about the unfair, the 1977 Unfair Contract Terms Act that you said it was promulgated. Please be careful in the use of your language. You should know the difference between when you promulgate a law and when you enact a law. So, do you get the point I'm making, Grace? So,
yes, sir.
Yeah, so because of example, be careful in using your terminology very well. So, an act can only be enacted.
Okay, sir.
You can't promulgate an act. It's only you promulgate a decree. So
okay.
Then again, I also advise that you read the case of Higgs and Foster on that aspect of a trespasser, which relates to trespasser. So if you are put this in proper perspective that for love visitors, the duty of care is high, but for the trespassers is less. So, but when you read the case of Higgs and Foster, you understand the rationale behind all these principles. Then again, Michael, before I go, I think Michael has something to say. Michael, do you have something to say before I put my final take on this?
Good morning, sir.
Yeah, morning. Yeah, go ahead, Michael. We have 40 minutes to go. Go ahead. I actually wanted to take like almost 20 contributions on this topic today, but a bit of time, we'll manage what we can manage.
Okay, sir.
Yes.
I just want to make a slight contribution as to the 3 terms that you told us to make research on.
Yes.
The first thing I want to bring to the attention of the class is that the terms, as discussed, the uses of these terms are very, very, very kind of obvious in their names. So they can be likened to these normal notices that we find around. And I think it was Grace. She made a mention of in determining the extent to which these notices can actually affect the liability of an occupier. It is very important for one to look at the intention behind the use of these notices. So for exclusion notices, it's very important to keep in mind that a place where one is not permitted to be, one cannot possibly say is a visitor there. Let me say, for example, you have a property or a premise, and on that premise, you carry out some industrial works that actually lead to having smoke on the premise. And there is a notice outside that says that people that have what's the name of this sickness? These people that have this sickness that they usually have shortage of breath, that they are not permitted to be on the premises because there is always industrial.
Asthma?
Asthma. Yes, asthma. That they are not permitted to be on the premises because of the industrial work ongoing that produces smoke. To that in that scope, we would say that if somebody without the intention of having any without ulterior motive, maybe the person doesn't have any ulterior motive, perhaps he wants to go into the property to see somebody, or maybe somebody invited him to the property. If that person, after seeing the exclusion clause, still goes in, knowing that he's asthmatic, whatsoever damage that is done to that person, we cannot properly say that we will be saying the liability of the occupier based on whether the person is a trespasser or if the person is a lawful visitor. So the intent behind the these notices are very important, because for exclusion term is used in various ways. I can use an exclusion term or exclusion notice to say that, oh, I don't want this person on my property. Or I could also use it in the form that, oh, you can come into my property, but when you get into the property, you are prevented or stopped from doing this particular thing. So the balance between one being a trespasser, a lawful visitor, or one even going into the scope of being from an ab initio perspective, it's very, very fluid. And depending on how these notices are used, that's why the intention behind the notices should be balanced or should be considered before actually coming to the conclusion that, oh, this person is a trespasser or not a trespasser. As per disclaimer, I think the intention behind disclaimer is not to fully absolve the occupier from liability. The intention behind disclaimer is that, oh, if this and this should happen, then I am not going to be liable. Okay, for example, from the normal word disclaim, to disclaim means that I am saying that I'm not responsible for this if you should do this. So it's possible for me to also bring someone to my land. Okay, you are permitted to come into my property or into my premise. But if you go beyond this level, this would happen. And if you actually go beyond the level and that happens, I can bring that up as a defense in court that, oh, I told him not to do this. I told him not to go to this place and he didn't listen to me. And that is why this happened. Or I could also say that, oh, I have petrol on my property or on my premise, that if you should actually smoke there, that whatsoever happens, I am not responsible. So I believe that the influences of these notices on the liability of an occupier is not fixed. It's not really fixed. So for the court to determine as to what level these notices can either absolve or limit the liability of the occupier, it is a question of fact, and it's also a question of intention. And intention, or which is motive, before intention, which is motive, before it can be determined, it's very important for one to look at the actions behind or let me say the actions that the person has put in place before determining the intention of the person.
Yeah, I think, Michael, at least that's a good place to end it. So, in fact, you have put that a final may I say nail into discussion. Now, the one I always give every year when I teach this topic is that ensure that you understand all these principles very well, whether disclaimer, whether exclusion clause, whether warning. Look at the intention, and the fact of each case will determine the extent of liability of an occupier. A class, do you hear my statements? I said the fact of each question will determine the extent of liability of the occupier. So read the facts that may come your way. Look at the situations from the scenario and ask yourself, having all these principles as enunciated in this class, can we say an occupier is liable to a trespasser who, despite seeing the warning, move into the property of an occupier? To what extent can we say an occupier will be liable to such a trespasser? At the same time, to what extent can we say it's liable to the visitor? If you look at the case, who is okay? Ali, I'm coming to you, Aliyah. I'm going to you. I want so I don't forget this thought. You know, I don't want to forget this thought. That's why I'm saying this. So let me just finish. I'll come back to you. I have like 5 minutes to attend to Aliyah and I don't want another person. So now, just get this part so I don't forget, because I have many things in my mind that I keep on forgetting because of presentation that is taking time. Now, the case as X-ray by Grace as well, which is the case of Rose and Nathan on warning. That is really important. Okay, so if a house has a river in front of it, and the sole means of access to the house is by crossing a dangerous bridge, the occupier will not secure a defense by simply affixing a sign stating that the bridge is dangerous. No, you must provide alternative. You must provide alternative. So the sign will not make visitors safe, since they will have to use the bridge anyway. That's only bridge that is accessible to the property. So it will not be absolved of any liability in that situation. But it will be different if, however, there were two bridges, as explained by Grace, and they noticed on the dangerous one visitors to use the other. So the occupier will bear no liability for injury caused to a visitor who was injured through ignoring the warning and using the dangerous bridge. So just know the fact, read the fact of each case and apply the principles that we have discussed in this class. You'll be happy at the end of the day. By the time you see your question, you will see that nothing is totally different from what we are saying in class. I just want you to put your thoughts together to say, oh, okay, if A happen, the result will be X. If X happen, the result will be Z. So know all these facts, know the principles, and use cases to back your postulations. And with that, we are good to go. So, Aliyah, you have 2 minutes.
Okay, good morning, sir.
Good morning.
So basically, most of the crux of what I wanted to say has already been spoken
Wait,
about.
Aliyah, let's see your good face now. You know what class to see your face?
Okay, can you see my face?
Okay, all right.
Okay, so, but I just wanted to just bring everything together. So as we all know, the common duty of care under the Occupiers Liability Act of 1957 requires occupiers to ensure visitors are reasonably safe for their permitted purpose, like as codified under section 2, subsection 2, right? So this standard actually varies with different circumstances, just like as you have mentioned. It depends on the particular case, but like some things that are worthy of note is, children's vulnerability, as illustrated by the Phipps versus Rochester Corporation case, or professionals' expertise, just like as you mentioned, the rules versus Nathan. Trespassers are governed by the Occupiers Liability Act of 1984, and they are actually owed a narrower duty if the occupier knows of both the danger and the trespasser's presence. So the common duty of care, as codified in section 4, subsection 1 in from Lagos State reform law. Yes, thank you. It establishes that an occupier owes the same duty of care to all visitors. Importantly, this duty can be extended, restricted, modified, or altogether excluded by agreement or otherwise. So this provision is actually like the legal foundation for the various types of notices that we will now examine. So disclaimer notices, as I think John mentioned earlier, is just to disclaim, right? So it is a statement issued by an occupier that attempts to deny responsibility for injuries or damages suffered by individuals on their premises. Unlike exclusion notices, disclaimers do not explicitly limit liability, but may influence the application of the principle of voluntary non-fit injuria, which is like the voluntary assumption of risk, right? It does not necessarily form part of a contractual agreement, but it is simply a unilateral declaration by the occupier. So we have to examine that under the Lagos State law, under section 4, subsection 4, it provides guidelines for whether an occupier is discharged from the common duty of care. So like if you put like a sign at like a rock climbing facility that says climb at your own risk, right? It still lends credence to the fact that disclaimers are ineffective against liability for death or personal injury, as put under section 2, subsection 1 of Unfair Contract Terms Act of 1977, right? But for property damage, reasonableness under UCTA applies, as seen in Smith versus Eric Bush, right? But in White versus Blackmore, a disclaimer at a jalopy race event failed to absolve liability because the danger, which was like the faulty safety barriers, was not like exactly inherent to the activity, right? Similarly, I think in Stearns versus Royce B. Peck, the defendant still argued that its disclaimer notice exempted it from liability when a customer was injured by a defective shopping rack. The court held that the disclaimer was not sufficiently brought to the plaintiff's attention and was therefore unenforceable. But like now that we talk about an exclusion notice, it is a formal statement which is often incorporated within a contract. At least that's what my research showed, and it expressly limits or excludes liability for harm suffered by visitors. Unlike a disclaimer notice, an exclusion notice aims to legally restrict the rights of a visitor to claim damages by clearly specifying the limits of the occupier's responsibility. Under the UCTA of 1977 and the Consumer Rights Act of 2015, exclusion of liability for death or personal injury is void. And similarly to disclaimer notices, for property damage, exclusions must also be fair and reasonable as well. So, for example, an exclusion notice may go.
So, Aliyah, you know what I'm going to do is that because of time, so maybe before I start my lecture, my tutorial, my tutorial or lecture next week, I know on Wednesday, so we can take 20 minutes or 15 minutes to wrap up on this point, because I could see the definitions from the group, and that's nice, that's good. So on that note, please Joy, so Joy, you have opportunity to also contribute next week. Then Mary Ogu will also have opportunity to contribute next week. So let's leave it at that for today. And
something else, sir.
But no, there's no time. This is 11 o'clock.
I'm sorry, not on the.
So they're already waiting for me in housing law. The housing law starts in 11. This is 11:01. It will be unfair on those students that want to make their presentations as well. Okay, so just note your points, and we'll meet by the grace of God on Wednesday. Okay?
Okay, sir.
All right. Bye.